Welcome to Comply on the Fly with M3 and Karen B, your trusted resource for quick, reliable insights into employee benefits compliance. Each episode delivers clear answers to common compliance questions. Whether you're tuning in for the first time or you're a seasoned listener, we're here every other week to make navigating compliance a little easier. Please note this podcast and the contents herein do not constitute legal advice. In all cases, employers should consult with their own legal counsel. Let's dive in.
Hello, everyone. I'm Karen B. And the Comply on the Fly topic today is HIPAA. Specifically, this is a call to action if you, as the employer, sponsor any self-funded health plans. For instance, self-funded medical, self-funded dental, health reimbursement arrangement, individual coverage health reimbursement arrangement, or ICHRA, or a medical flexible spending account, or FSA. If you are the plan sponsor of any of these self-funded plans, you probably know that these plans are considered covered entities under HIPAA. Please note that HIPAA does apply to fully insured health plans, but typically the insurance carrier for those plans has the HIPAA obligation and does not share protected health information with you for those plans. It is probably also a good time to remind you that your ancillary lines of coverage, such as long or short-term disability, are not covered under HIPAA. Now, with all that background information, for those of you that sponsor any self-funded health plan, including the account-based plans like the HRA or medical FSA, a compliance requirement applicable to you under HIPAA is for you to provide a notice of privacy practices to individuals that enroll in any of those plans. Timing for the delivery of this notice is upon enrollment and then once every 3 years or upon request. And if any changes are made, a new notice must be provided within 60 days or provided with the next annual notice. We typically advise that you can include it with your new hire and annual enrollment materials, and then you have your bases covered for delivery. This notice is included if you have M3's benefit guide or model notice booklet. So what exactly are the changes and when are they required? The changes are specific to 42 CFR, and that stands for Code of Federal Regulations, Part 2, also known as Part 2 records, which pertain to substance use disorder patient records. Updated notice of privacy practices must include the following. Part 2 records may not be disclosed or used in criminal, administrative, or legislative proceedings without consent or a court order. Disclosure of Part 2 records may be made pursuant to a general consent. However, individuals can limit these disclosures by only providing consent to disclose specific information. Information properly disclosed by a covered entity under HIPAA could be improperly redisclosed by the recipient of that information and no longer be protected by HIPAA. And then finally, if Part 2 records will be used for fundraising, to benefit the covered entity, individuals have to be able to opt out of receiving the fundraising communications. This is rarely applicable to self-funded health plans. So these changes that have to be documented in the Notice of Privacy Practices are required by February 16th, 2026. So what is your call to action? If you're required to provide a notice of privacy practices by virtue of sponsoring any self-funded health plan, we encourage you to review your current notice of privacy practices and make the necessary updates. If you need an updated template of the notice of privacy practices that includes these changes, please contact your M3 team. An updated notice of privacy practices will be included in benefit guide materials and the model notice booklet going forward. And that is your Comply on the Fly topic for today. Thanks for tuning in.
For more employee benefits compliance insights from Karen B and her team, please visit m3ins.com.